Hello, February 9th, 2023. Welcome. I'm your host, Reza. And today we will cover the LMI exempt work permits under the Canadian Interests and Significant Benefit category under the Immigration Regulations 205A and 204C. Some of you may know these categories as temporary immigration programs such as C10, C11, or even T13 LMI exempt codes. These programs are typically for entrepreneurs, investors, and self-employed applicants who demonstrate the ability to create significant benefit for Canada. Interestingly enough, even the startup visa work permit applicants are considered now under the C10 LMI exempt work permit category. So why and how would these types of applications for work permits to come and start your own business or even buy a business be refused by the IRCC, the Canadian Immigration Department? That's the topic of our discussion today on our weekly Thursday live stream, 100% raw, no censorship or editing. Quick introduction, my name is Reza, your host, and I work with the Ingwe immigration team helping applicants move to Canada. Whether it's for yourself, your kids, your business, or all of the above, we do make it happen. Let me make this clear. I am not an actual full-time YouTuber, although you do see me on YouTube twice a week, but I work hands-on with our licensed team, working on actual applications and communicating with the immigration departments, both inside the country and overseas, on a daily basis on behalf of our clients. These videos are made for the purpose of sharing our hands-on immigration knowledge with our worldwide audience. And if you're thinking about immigrating to Canada, well, we're here to help. Get a free email assessment by filling out the form below this video for eligible applications. Let's jump into it, folks. One of the key criteria which the officers look at in this part of the regulation is the 205A. Okay, I don't want to throw legal mumbo jumbo at you, but this is the wording, what it says. A work permit may be issued under section 200 to a foreign national, which means you, the applicant, who intends to perform work that would create or maintain significant social, cultural, or economic benefits or opportunities for Canadian citizens or permanent residents. So the key words here are create or maintain and significant benefit. It could be economic, social, or cultural. Maintaining means perhaps you're saving jobs or a business from going under, maybe. Creating is creating jobs or creating economic or social benefits or cultural benefits. So for applicants who are from free trade agreement countries, they can also utilize the regulation 205B. So under this regulation, it says a work permit may be issued under section 200 to a foreign national, you as the applicant, who intends to perform work that would create or maintain reciprocal employment for Canadian citizens or permanent residents of Canada in other countries. But this is not the subject of our discussion today, maybe in the future. So we will focus on the 205A significant benefit for Canadians. In most refused work permit applications under any of these LMI exempt work permits, IRCC officers will focus on the significant benefit for Canada wording which has been included in these regulations, which is why we will review them today, and how IRCC officers will use them against you or find ways to refuse you, even if you're a genuine investor or entrepreneur. The specific wording in the instructions for these programs is that it is intended to provide an officer with the flexibility to respond in situations where the employment activities of the foreign national would create or maintain significant social, cultural, or economic benefits or opportunities for Canadian citizens, people registered as Indians under the Indian Act, which is Aboriginals, or permanent residents of Canada. Sounds pretty simple, right? But obviously, there's a lot of discretion here, folks, for the officer who's using these regulations and instructions to make a decision on your application. Let's review a few cases which went to federal court that were refused in these categories. This will provide you a better example of what to watch out for when you're preparing your application in these programs. So the first case, the officer concluded that Mr. or Mrs. had not demonstrated that he or she met the requirements for a work permit pursuant to Section 205 of the regulations, which is the same regulation we just referred, which the officer noted as significant benefit to Canada, and was not satisfied that he or she was exempt from an LMIA. And the Global Case Management System notes, which is, you may know them as the refusal notes or the CAPES notes, says the application is for C11 entrepreneur in a specific province. So I'm just removing some of the identifying marks. And according to the business plan, the applicant proposes to offer residential and commercial home decor products and furnishings imported from X country, right? Specific country overseas. The GCMS notes also state that the foreign national applying to work for themselves or to operate their own business on a temporary basis must demonstrate that their admission to Canada to operate their business would generate significant economic, social, or cultural benefits or opportunities for Canadian citizens or permanent residents pursuant to paragraph Regulation 205A, which we obviously just covered. Given that there will be no products manufactured supplied from Canada and the job creation is minimal, it is difficult to see the significant benefit to Canada. The business plan provided does not indicate how the principal applicant's involvement will provide economic stimulus, job creation for Canadians, and or significant benefit to Canada. This is the wording from the officer who refused this application under C11. So this is the background. Mr. Mrs. whatever of resident of so-and-so country, who were the applicants, proposed to immigrate to Canada to open a home decor business in a specific province. Mr. and Mrs. name plan to lease a retail space in a specific neighborhood in that province or region or city, hire 2 staff, and use other local vendors to support their marketing efforts for their new business, which they plan to set up, which would sell imported goods in Canada from abroad, which they're importing. Mr. and Mrs. name was approved as a provincial nominee candidate under the provincial nominee program work permit stream. A candidate is not a provincial nominee, rather a potential nominee. So they haven't received a nomination for PR. A letter of support for work has been issued by the province. In accordance with the terms and conditions of the program, he or she, the applicant, was required to obtain a temporary foreign work permit from Canada upon arrival, reside in a specific province under the provincial program, and invest at least 150,000 Canadian dollars in an improved business. Interestingly enough, the applicant did not apply under the T13 LMI exemption code with the letter of support from the province, but rather opted to do the C10 significant benefit entrepreneur self-employed LMI exam program. So that's an interesting one. However, you can see how they use significant benefit wording to consider and make a decision on an application. So in this case, the application for the judicial review was actually allowed in court. What to take away from this refusal case? If you're planning an import business with no added value in terms of processing products or significant size in terms of employment, then the IRCC officers won't like it, even sometimes the provinces. If you're going to participate in the export business side or add value by processing an imported product and processing it inside Canada, then that could have much more significant benefit for Canada and the economy. And the whole point is, even if this case was granted judicial review, it doesn't mean that the IRCC officer's decision is overturned. It just means it goes back to the IRCC, and another officer within the framework of the instructions of the law and the courts will reconsider this application and render a new decision. But the whole point is not to get refused in the first place, right? So here's another case, not specific to C10 or 11, but all about the applicant demonstrating that he or she would perform work that would create and maintain significant social, cultural, or economic benefit according to Regulation 205A. So the applicant had a business plan to open a bubble tea shop in a specific city or province. He or she applied for work visa based on an LMI exemption via the support letter from the province under the PNP program, right? While an officer is required to acknowledge and consider the support letter from the province for the work permit of the applicant, there's no requirement, or it's not mandatory, for the IRCC officers to actually agree with the province. Officer's notes read that the applicant did not provide a specific address for his or her business. His or her business plan was vague in respect to purchasing a property even. The viability of a bubble tea shop in the specific city and how it would compete with other tea shops, how the applicant would cover the expenses of the Canadian Pension Plan, CPP, and employment insurance contributions, and other discrepancies which we won't get into today as they're not relevant to our topic. So the applicant in this case actually mentioned that they won't be paying the CPP and EI, which is mandatory for payroll in terms of employment insurance and Canadian Pension Plan, but not if you're either the business owner, so you can opt out, or you're a family member of the business owner, so arm's length sort of relationship, non-arm's length relationships. But this is optional, and there's specific Canadian Revenue Agency requirements for that, to opt out as a business owner, to pay these every time you pay yourself a salary, right? So I'll get into that quickly. In this case, the application for the judicial review was actually dismissed, so they didn't get a chance to actually ask IRCC to relook at that file. What to take away from this refusal case? You cannot be vague in your business plan or intentions. You need to sign a lease or have a deposit agreement in place to use it as your business premises where you want to start this business, or if you're already buying a business, then there's already a premises. This is a basic requirement we have for all C10, 11, and C12 applicants, at least the ones that work with our office. So the discrepancies, you got to be careful with discrepancies. It should not be allowed in your application or in your intentions to set up in Canada. Why would anyone propose not to pay the CPP and EI, the Canadian Pension Plan and Employment Insurance, in their business plan? If you don't want to pay as a business owner based on the regulations in the CRA, that means your own salary, you want to opt out of these mandatory payroll source deductions, which is allowed, but don't tell IRCC upfront in your business plan. What are you thinking, man? You can do it afterwards. You don't need to tell them that. The business plan in your application indicates your intentions and plans. And as well, we all know intentions and plans can change any minute, right? This was a poorly prepared application from my point of view. Many other refuse cases for C10 or C11 LMI exempt work permits for entrepreneurs and self-employed use similar wording as I'm going to describe now below. The business plan, so these are quotes from IRCC refusals notes. The business plan acknowledges that there are already competing nearby businesses, okay? Similar offerings of the service or product that's been proposed by the applicant. Of note, while reviewing information available via Google Maps within 1 or 2 blocks, it appears that there's other businesses offering similar products or services nearby, not included in the business plan. So that means the officer actually went online and did their own research, especially for retail, which is much easier. For nationals applying to work for themselves or to operate their own business on a temporary basis must demonstrate that their admission to Canada to operate their business would generate significant economic, social, or cultural benefits for opportunities for Canadian citizens or permanent residents pursuant to paragraph 205A, which is the regulation of significant benefit. While the establishment of this business is likely to create a viable business for the owner, the services and goods to be provided are not unique for this business, especially when considered the proximity of other similar businesses nearby this proposed business. Despite the claim that the company intends to hire highly competent Canadian citizens or permanent residents, it is more likely that the establishment of this business, right, the specific business that is in the application, will create minimal low-wage opportunities that are unlikely to benefit Canadians or PR workers or provide significant economic stimulus to that region. This is the wording from the refusal of the officer. Based on the documents provided, I'm not satisfied that the applicant's request to enter Canada as the owner of this business comes within the exceptions for an LMIA of Regulation 205A, and that the issuance of this work permit would generate economic benefit, significant economic, social, or cultural benefit to Canadians' permanent residents. I'm not satisfied that the applicant will be providing a unique goods or services that the applicant's work experience will improve the viability of this business, or that this business will create significant job opportunities for Canadians or PR workers. So there's two key criteria that you need to understand about such refusals for entrepreneurs, investors, and self-employed applicants seeking LMI exempt work permits. The first one, IRCC has a genuineness guidance manual for its IRCC officer, which is used to check genuineness of certain types of applications. For example, an offer of employment from an operating Canadian company to a temporary foreign worker, it asks in the manual, it asks the officer to call and request more info from the employer in Canada to test the genuineness and validity of the job offer. But in cases where the entrepreneur or self-employed applicant is issuing themselves a job offer from a newly established entity in Canada, then what do you think the RCC officers will depend on? They will scrutinize their business itself and whether it meets the significant benefit test. It's simple because, there's literally, it's a new business, right? It's simple. The focus will shift from you as the applicant, and since there's no Canadian operating business employing you, the focus will be your actual business plan and the intentions inside Canada. This is what they've been trained to do, and they will do this on every single application. Sometimes it may not be in your favor or beneficial to even apply for an LMI exempt work permit. What does that mean? If you have an operating business inside Canada, either purchased shares or you started it from scratch and it's operational, it's got expenses, revenue, staff, then sometimes it's just easier to apply for an owner-operator LMIA, which is just an LMIA, a labor market impact assessment. So you don't go the LMI exempt stream, you actually do the LMI. In this case, the officer can only focus on you, your skill set, your work experience, your education, your language ability, and the genuineness of the job offer. Significant benefit is not in play anymore because you're not applying under the Regulation 205A in terms of creating that significant benefit for Canada, correct? Because you're doing an LMIA and it's not an LMI exempt work permit. So there's many applications that are approved and many that are refused on a daily basis by RCC under the C10, 11, and T13 LMI exempt work permits, which is the Provincial Nominee Program exemption codes. I can only suggest you the following tips and advice if you're considering these. Prepare your application and business in detail. Don't rush it and don't generalize when you're preparing the application and plans. The more details you put into your application, showing how in-depth your research have been, and the more investments you've put at risk in terms of having already invested, expensed, signing agreements, and making the business operational, the more likely it is that you will be approved. You need to spoon feed the IRCC officer in terms of the regulations under which you're applying and how this business meets the immigration refugee protection regulations and the criteria, such as significant benefit if you're doing the LMI exempt work permits. Whether it's economic, social, or cultural, you need to clearly outline why and how this benefit is created and quote external sources that agree and validate your findings or the fact that Canada actually needs this. Last but not least, you don't focus on setting up any business or franchise inside the big cities if you're not investing in enough or if it's not a unique product or service. The bigger the city, the bigger the investment and benefit required. If you go to a rural or regions outside of the major cities, you have better chance of proving significant benefit for Canada, for your operations or this business that you're proposing. And again, you need to spoon feed this to the IRCC officer in your submission and application. There you go, folks. And why should you subscribe to our YouTube channel? It's simple. We covered the information the IRCC does not want you to know or be shared in public forums. You can either be stuck in this IRCC information machine, or you can break free, just like the Matrix. The choice is yours, folks. Take the red pill, or will you take the blue pill? If you're thinking about immigrating, whether permanently or temporarily, whatever the program is, LMI or not, business, investment, family, free trade agreements, education, and so forth, you're at the right place. I can guarantee you only one point. You'll know what to expect. The entire process clearly laid out for you, and all the risks identified, including all costs. And our legal agreements are based on payment milestones, which are linked directly to your application progression. We do not take 100% advance payment for your Canadian immigration application. There will be no surprises in terms of expense or cost, and just results. We have a $1 million liability insurance which protects you and us from fraud and mistakes, and a dedicated client trust account with our Canadian banks. Our team speaks over 8 languages, and we're helping people, applicants from over 48 different countries right now, and this list is growing. Click the link below this video and get a free email assessment after it's posted, because it's alive. But if you're watching this later, you will see the link below. And if you need to apply ASAP, you're serious, you want to go forward with it, you can also book a one-on-one consultation with me or any of my colleagues at Ingwe Immigration using the consultation link, which will also be posted below this video. And if you have questions, remember we're here every week, Thursday, live on YouTube, Facebook, and Instagram at 11 a.m. North America Eastern Standard, where we answer all of your questions for free on the spot. And yes, we are live today. Thanks everyone for joining us. Quick note to Facebook and Instagram viewers, we do not see your comments and questions live during this session because of limitations with the streaming platform that we use. So if you have questions or comments, make sure you tune into the YouTube version, and that's where we are. We're going to look at everyone today. Say hello. And yes, we've got Nasrina Ibrahimi at the top of the list. Rosita, good to see you. Hello, Reza June. Asanka Delmel, good morning, sir. Asanka, good morning, or good afternoon, good evening, depending on where you are. Bhupinder Nanda, hi Reza, good morning. Bhupinder, nice to see you. Good evening. I know it's late right now in India. Mohammed Khan, good morning, sir. Good morning, back to you, Mohammed. Bhupinder says, can you please explain self-employed visa and it comes under which category? It leads to work permit or direct PR? Bhupinder, good question. So there's several categories of self-employed, right? You can do the LMI exempt route, right? Which is, I guess you're familiar, C10 11 work permits, which is based on significant benefit that we covered today, right? You can also go through the provincial program, but the federal programs, which I just covered, C10 and 11, it means you're starting a brand new business or maybe buying one. It's up to you. You need to prove that you're bringing significant benefit to Canada. They do not lead you to direct PR. However, if you are eligible for express entry, federal skilled worker stream, you could potentially claim bonus points after 1 year of running the business and being on payroll full-time for 12 consecutive months with your LMI exempt work permit. However, these points sometimes may not lead to PR for you in express entry. In your case, it wouldn't. And you can even do an LMI owner-operator, but again, these would not lead you to PR for you because the federal programs accept the startup visa and the self-employed, which is only for art, culture, and sports. The rest of the programs do not lead to direct PR. Only those 2 programs lead to PR. And then the provincial nominee programs, which is also significant benefit under an entrepreneurial stream, they will nominate you for PR. So you don't need to go through express entry, similar to what we discussed in terms of provincial nominee programs, in terms of investors and entrepreneurs. You don't need to worry about the points in the express entry stream. You start the process, and then you will eventually be nominated in Manitoba, 12 months, 6 months eligibility to be nominated for PR, right? So basically self-employed, to go directly to PR, it's literally only a few options. the federal programs are not direct PR. Okay, they're the first step in a multitude of different programs that you've got to combine to potentially be eligible for PR. Travel Vlogger says agriculture and livestock business in Manitoba, Canada, PNP. How to apply? Well, agriculture, they have their own farming stream, but if you've got livestock or other activity, of course you can come, do an exploratory trip, meet the eligibility criteria of the provincial nominee program, right? Your language ability, your ties to the province. You've got to prove what are your intentions. Will you stay in Manitoba? Because a lot of people do leave, so they're pretty sensitive on that. But yeah, the key is meet the eligibility of the provincial program, calculate your points in eligibility, have a business idea, come do an exploratory, prepare your business concept and plan, submit an expression of interest on the Manitoba Provincial Nominee portal. Almon says, hello, sir. Hello, sir. Back to you, Almon. Mohammed Khan says, minimum experience requirement for C11. There's no minimum requirement, but it depends on the position that you're issuing for yourself. If you're a CEO and you've been a middle manager most of your life, yeah, that could be an issue, right? The minimum experience, what I usually say is minimum 3 years. It's not documented anywhere for C11, but 3 years is a good minimum base to go. If you've got 5 years, even better. But it's difficult to use less than 3 years unless you have a pretty big corporation, massive money, a lot of investment, and you've been successful. Then potentially, yeah, maybe even 1 year. Right? So it depends case by case, Mohammed. Mohammed Khan says, it's a plus point to apply C11 while staying in Canada. It's you can go to the border and get a 3 to 5 hours. You can get your work permit if you apply at the border, flag pulling. But in terms of applying online, whether you're inside or outside, it won't give you any advantage. Only if you flag pull and do a paper application where a CBSA officer looks at it and renders a decision on the spot. That's the only advantage you have if you're inside Canada and considering that route for your C10, 11, or even ICT C12. Precarious is asking, hey, I wanted to ask if I get a PR as skilled immigrant, can I start a business or buy properties? I want to ask if I get a PR as skilled immigrant. Yeah, so Precarious, you can actually buy property. Well, now they've banned foreigners. I mean, it's ridiculous. But you can, yes, as a permanent resident, you can buy property. You can buy businesses no matter if you're PR or not. You can even buy a business without entering Canada. There's no restrictions on buying a business. Okay, so that's separate from PR being Canadian. Safa Saleh says, hi Reza, what is the main reason for refusal of work permits under SUV program? What is the top 3 countries of the rejection list and why? Ooh, interesting question, Safa. Good to see you, by the way. He also asks, can you do an appeal after getting a rejection of work permit? And what is the success rate of that? Okay, interesting. Yes, you can actually apply for judicial review under any immigration stream. So visitor visa, study permit, temporary resident permit, work permit, permanent residency under any stream. So it's possible, right? Usually within a 60-day framework, you could even apply after the 60 days, but you've got to have some good reasons for that. But however, what's the success rate? It depends. There's no approved success rate. Like right now, I'll tell everyone what is the success rate of startup visa PR refused appeals in federal court. The success rate, get ready for this, don't hold your breath, 0%. Yeah, that's right, folks. No single startup visa applicant who's been refused for PR has been successful in judicial review. That's a fact. For work permit, Safa, there's been approvals. There's been judicial review success. But there was recently a case where they grouped together 24, 25 applicants from a specific country, and the IRCC accepted to review all of them together because they came in as a group. But work permit refusals and startup visa are rampant, and it's all over the place. Okay, what is the main reason for refusal? Well, it's significant benefit and urgency. That's what I always say. On your letter of support and the start of visa, it says, why is it urgent for you to come enter Canada to run and start your business? And then under C10 that we covered today, LMI exempt work permit program, you need to provide what significant benefit is there for Canada or Canadians or permanent residents? Right, what is the top 3 countries of the rejection list? I would say that, well, the number 1 country I know, I'm not going to name it, but I know it. Number 2 and 3, it's all over, to be honest with you, Safa. It depends on your region. So if you're from like Germany, obviously you're not going to be on the high refusal region. They're going to give you the work permit, right? It's also based on if it's a high volume region. So if you're from India and there's so many applications there, obviously there's more refusals and more approvals, right? But I would say Africa, Middle East are definitely on the hit list, Hong Kong and mainland China. But again, if you've got a good startup, solid progress, if you don't show what you've done and what you're planning to do, what is the significant benefit? What is the urgency? You don't have a product or service and you're coming, what are the meetings you've lined up? Partners, academic research, collaboration, hiring. Maybe you've hired somebody in Canada. You need to go manage them, otherwise they'll lose their job, right? This is all just ideas for you folks. Hayat Khan says, hello Reza. Hello back to you, Hayat. Nice to see you. Muhammad Khan says, in C11 work permit, can you allow anywhere in Canada in different times? Yes, just stick to outside of Quebec. So, because you know, federal immigration doesn't even apply in Quebec. So as long as you're outside of Quebec, anywhere you like, you can be in that area or region. Bhupinder says, thanks, Reza. I really love your way of explaining. Especially I love your smile. Thanks, Bhupinder. Appreciate it, man. I wish everyone was like Bhupinder. Always here on our live stream, but I appreciate everyone who's joined today. And so positive, Bhupinder. You know what, Bhupinder? I think Canada needs more people like you. You know, and I know you're kind of giving up your business in India and, you know, thinking about moving to Canada, but you know, it's a tough one for every applicant who's looking to immigrate out, right? But yeah, I love your positive attitude, Bhupinder. Surely coming back to you in March. No worries, Bhupinder. No rush. The fact that we interacted, we were discussing, I got to see you online as well. That was amazing. Thank you. And again, folks, I'm a first generation immigrant. My family is. I'm still immigrant. I actually immigrated to Canada twice. You can ask me later if you do a one-on-one consultation of how you can immigrate to a country twice. And no, I was not deported. Thank God. Knock on wood. Hassan Anbar says, hi there. Thanks for doing these live calls. I want to know what the difference between C11 and 12 is. I'm planning on applying using flagpole method from the US border since I have a US visa. Okay, yeah, you could also do flagpoling without a US visa, but you got to be very careful. Okay, C11 and C12. These are LMI exempt work permit, folks. They're part of the International Mobility Program, and they're all part of the significant benefit to Canada category that we've been talking today. Why did we not talk about C12? We've already covered it in our other videos. C12, okay, Hassan, is all about the business. It's all about the parent company, the headquarters, who are planning to set up a branch, subsidiary, or joint venture in Canada and transferring over a foreign staff member to Canada with a work permit. So the whole application is based on the eligibility of the business. Is it financially sound? Does it have money? Is it logical for it to come here and set up a branch or subsidiaries or invest in a business here, right? So the focus is that. That's the key, right? C11 is the focus is you. The focus is you as the applicant investor. Do you have the credibility? Do you have the eligibility? Do you have the worker? Do you have the money? Are you bringing significant benefit? In C12, the person they're transferring over will also be looked at on a temporary foreign worker basis, right? But the majority of the application, when we prepare, 90% is based on the business itself overseas. And the ownership structure, the control, the financials, how many people are there, who's going to run the business while you're away as an executive shareholder or key staff. And C11 is about you. C11, usually we use C10, just so you know. C11 we like to use more for self-employed persons who typically don't hire or set up like a big company or anything like that. So if you're a web designer, an author, an artist, or just, you know, independent, usually we use C11, and we use it for shorter term foreign worker LMI exempt work permits, not for longer term. If you want to set up a company and eventually, you know, stay here and convert to PR, we typically, depending on your occupation, if you're a business owner, we do C10. If you're an independent self-employed person, we would do C10 there, C11 here. Yeah, sorry, mix up these numbers sometimes. So I hope that was a rough idea, give you a rough idea, Hassan. Safa says, thanks, Fez. I feel you're more optimistic than before. No, Safa, maybe I'm just hyper today. No, I'm not optimistic. There's a lot of refusals. Obviously, you take them to judicial review. You've got to do your application correctly. And the thing is, this is one piece of advice for startup visa applicants, okay, or anyone who has a business or planning to start a business. Sometimes you got to get certain things rolling in terms of the business operations before you apply. So don't apply just for the sake of applying. Oh, I applied for my PR, or now I'm eligible for this work permit, I'm going to apply. No. Wait till the time is right. Have you ever baked a cake? Have you ever watched it in the oven while it's baking? It's got to be perfect. So think about that. Don't just apply and be like, yeah, I'm eligible, I'll apply. What have you done to overcome the IRCC officers' doubts or their typical refusal reasons, right? Have you put everything in place to show your product, your service, your significant benefit, what you've done overseas, what you're capable of, and all your contacts in Canada who are waiting for you, right? So put it in place, then apply. Don't just apply because you can. That's ridiculous, right? That's like kind of like, I don't know, don't have an analogy for that, but you just don't want to do something because you can. You got to do it because it's the right time. It's like an investment. Everyone knows the investment is all about timing, patience, and cost-benefit analysis. Same thing with your applications to come here on LMI exempt work permits or any other kind of self-employed investor entrepreneurial programs. Okay, I talk a lot, folks, I know. Okay, Hassan Ambar says, I have a business that's making almost 1 million Canadian per year with 30 employees, and I have Canadian clients as well as Americans. You're good to go. I will most likely schedule a consultation. Thank you for your answer. No problem, Hassan. You've got a good business. I wish all applicants had a business like Hassan. And yeah, you're good to go. You just have to pick the right program, because think about it, Hassan. You have to think about what you want to achieve at the end. So think about the end game, right? Your exit strategy as a work permit holder. Like how, if it's PR, then we got to reverse engineer, see how we can obtain that PR, and then plan to apply under whatever program there is, whether it's LMI exempt or not. Muhammad Khan, I have more than 10 years as a concrete finisher. Should I qualify self-employed? You can, but you have to put certain things in place, Muhammad, about this business in Canada. So if you're here, start the business, right? You can't run the business, but start it, invest, right? Maybe get a partner to start and then apply, because then that will show that your intentions have become reality and there's already benefit. It's tangible. And what IRCC officers love to do is always shoot down your business plans and say, yeah, I don't believe you. I don't think this is going to be beneficial. But if you do it and you show it to them with proper documentation, then it's much more difficult to refuse dues. But yeah, of course, they can refuse anything they want. They're like, you know, they're like the machine, the IRCC machine. That's what we should call them. Thanks a lot, love. Bhupinder, thank you. Have a great day. Appreciate it, folks. We're here every Thursday. If you're watching this and you're like, why is this guy talking so much? Well, who is he talking to? Talking to the YouTube commenters and people, our audience who are asking questions. I'm here every Thursday, 11 a.m. North America Eastern Standard Time on YouTube, Instagram, Facebook, and on YouTube we get to answer questions and comments. I hope they're positive comments, but you know, we're open to anything, folks. Samira Manamperi, a work permit to PR English test is mandatory. A work permit to PR. Okay, well, Samira, all the PR programs have strict eligibility criteria. So it depends, are you going express entry? Yes. Are you going provincial nominee program? Eventually, yes. May not be upfront depending on a province. If you're doing anything, you know, PMP, it could be optional. You could get points. If it's a TR to PR pathway, like international students, that was, you know, the last few years, yeah, it was necessary. So Samira, all the PR programs typically need English. BC doesn't. If you're a master's graduate in Ontario, it's not mandatory. So certain programs, it's not mandatory. Family sponsorship, not mandatory, right? But if you're going through express entry language ability is 100% mandatory, okay? So if you let me know what program you're thinking about, then I could probably answer you more clearly. Mohammed Khan says, thanks a lot. Have a nice day. Thank you, Mohammed. Have a wonderful day as well. Nasreen Ibrahimi, who we call Rosita, one of our very dedicated audience members here, is almost here every week, says, good luck. We wish everyone luck in their IRCC, fighting against the IRCC, the machine. We call it the immigration machine, IRCC. Precarious. Is there a way to get a PR through investment or buying business like gas station, grocery? Yes, there is, right? Either provincial nominee program, maybe the Ontario Success Initiative, which is also provincial nominee program, or maybe you've got a great profile for express entry. You need those bonus points, and we take you through a C10 or C11, depending on your case. Again, depending, yes, it's possible, precarious, but we'd have to check your eligibility, your profile, and suggest the right program for you. Not every program is built equally. Not every profile of applicants is the same. Hence, you've got to do your homework. Okay, folks? Thanks for watching. We're back next Thursday, 11 a.m. on the dot, North America Eastern Standard Time, which is basically local time here in Toronto, Ottawa, Montreal, Miami, New York, New Jersey, you name it. Maybe even Detroit and Windsor. So many cities on the East Coast, right? We're back next week. Thanks again. Take care. We publish 2 videos a week. One is produced video, which usually is released on Tuesdays or Wednesdays, and one is our Thursday live session. This video will also be posted, this live, on our YouTube channel and other social media. Stay tuned, folks. We're always here to educate our applicants and the audience overseas of how you can overcome and fight the machine that is called IRCC. Okay? Take care, everyone. I hope you have a wonderful Thursday.